DORA for a fintech. The EU has turned operational resilience from a matter of good practice into a matter of law, and fintechs are squarely in scope. Here is the shift. The Digital Operational Resilience Act, DORA, Regulation EU 2022-2554, has applied since the 17th of January 2025. The ability of a financial firm to withstand, respond to and recover from an ICT disruption is now a legal obligation, supervised and enforceable. It is no longer discretionary. And fintechs are not a footnote. Payment institutions, e-money institutions, crypto asset service providers and many others sit directly within DORA's scope, often without the compliance machinery a large bank takes for granted. It does apply proportionally, lighter for smaller firms, but we are small is not a defense for having no resilience program at all. DORA is built on 5 pillars, and a fintech's program has to address each. First, ICT risk management, a governance framework for identifying, protecting against, detecting, responding to and recovering from ICT risk, and notably, one the management body owns. Second, incident management and reporting, firms must detect, classify, and manage ICT incidents, and report the major ones to their competent authority within defined timeframes. And then 3 more, resilience testing, from vulnerability assessments up to threat-led penetration testing for the most significant firms, ICT third-party risk management, and information sharing of threat intelligence across the sector. For a fintech, the sharpest pillar is usually the third-party one, because a fintech is often more integrator than infrastructure owner. The product runs on a cloud provider, payments flow through a processor, identity is verified by a vendor. Each of those is an ICT third party, and DORA holds the fintech responsible for the resilience risk they introduce. This is the principle that runs through every serious framework: you can outsource the work, but not the accountability. DORA turns that into concrete requirements: a maintained register of your ICT providers, prescribed contractual terms, and credible exit strategies, because a provider failure with no way out is exactly the scenario DORA exists to prevent. A recurring theme is governance. The management body is explicitly accountable for the ICT risk management framework, must approve its key elements, and is expected to know enough to challenge them. Resilience is not something the board signs off to the IT department and forgets, it is a duty the board itself carries, like financial risk. So how does a fintech get ready? Map your critical functions to the ICT that supports them. Build the third-party register and fix the contracts. Make incident handling real and reportable. Test at the right level. And put the framework in front of the board, with the evidence, because the accountability is theirs. The through line is familiar to anyone who has audited a modern financial firm: identify what is critical, control the providers you depend on without pretending you have handed them the accountability, and prove your plans work rather than assuming they do. So carry this away. DORA moves operational resilience from a good idea to a legal duty, with a register to keep, incidents to report, tests to run, third parties to control, and a board that must own all of it. For a fintech built on other people's clouds and APIs, it is simply the law catching up with how much rests on making that stack resilient.